President.
Mr. Vice President, I was literally at the point of dealing with the concept of exceptional circumstance. So if I were to rethread the matrix, we are saying, number one, Senator Vera said, no part of Bail Act should operate as a court-free zone. Submission number one, nothing in this amendment, nothing in the Bail Act as amended by Act number 17 of 2019, that is what we last did, nothing is a bail-free, court-free bail consideration zone. Absolutely nothing. The 2 points that I was making, point number one, the express language of the Bail Act as amended and as is proposed to be amended demonstrates clearly that the court has a complete supervisory jurisdiction. And number two, I'm going to go to the case law which treats with that. And I was on the point of Senator Vera having said, the question is, where do we find satisfaction with the concept of exceptional circumstances? I'll remind, Section 5.1 of the Bail Act says that subject to subsection 2, a court may grant bail. That means the court has jurisdiction in every circumstance. Section of the Act, Section 5.1 says the only place that you won't get bail is for capital offenses. That was the 1994 Act. We then went on to look at Section 5.7a. Section 5.7a of the Bail Act is what we put in a few months ago. That is, in exceptional circumstances, you can have the right for a court to consider your application for bail. Question is, what does exceptional circumstances mean? And I was making the point that we didn't pluck exceptional circumstances from the ether. We, in fact, brought the concept of exceptional circumstances directly out of the United Kingdom and the United States and Canada. And, Mr. Vice President, we did that because originally in 1994, when Keith Sobian piloted the bail amendments were specifically said to be in the context where the person should prove why bail should not be granted. Let me repeat that. In 1994, the Bail Act was produced. Section 5.1 said you can't get bail for a capital offense. You can't get bail in subsection 2 matters. In the Bail Act in 1994, they said effectively the accused should show cause why bail should not be granted. For 22 years thereafter, let me repeat that, for 22 years thereafter, right up until 2016, we changed that position. Successive governments, certainly for 11 years, beginning in 2005 to 2016, when the bail amendments all collapsed because the UNC would not support bail amendment law. In the 22 years that the 1994 Act stood, what happened was we had an ouster of the court for anti-kidnapping, for anti-gang legislation. We said that the court would effectively not be permitted to consider the grant of bail. In 2016, enter Anand Ramlogan, Gerald Ramdeen. When they were no longer in government, they went to court in the Daniel St. Omer case and they challenged the constitutionality of the bail amendments that they themselves put into law. And very fortunately for us, there is a decision on that, and I'll come to that in a moment. So exceptional circumstances exists. Now, let's jump to the case. Senator Vera has painted the point. What happens if somebody is framed on a first-time offense? He raised the example of the Sadiq Baksh matter, the grenade or rocket launcher or whatever it was in the tank. In those circumstances, the Bail Act must be read as a whole. The Bail Act says in section 5.3 that it's subject to, when you look at section 5.7a, it's subject to the consideration of exceptional circumstances. It is my submission that it is open to defense attorney, relying upon the fact that section 5.1 of the Bail Act says you have the right to approach the court, relying upon the fact that section 5.7a says you can ask for exceptional circumstances to be considered by a court. You can say to a court, I am not in actual possession, I'm in constructive possession. And let's put this narrowly. We are not talking about marijuana. We're talking about automatic firearms, and we're talking about prohibited weapons, and we're talking about trafficking in firearms. When you look to section 5 and section 6 of the Firearms Act, because that's what we're looking at here in this Bail Act, you are in unlawful possession. The element of that offense is that you must be absent lawful excuse. Let me repeat this. The bail amendments that we're considering today are to be read alongside the Firearms Act as amended. We amended the Firearm Act after we amended the Bail Act. We introduced into the Firearms Act the trafficking in firearms offense and the heavy weapons, the prohibited weapons. So we couldn't have amended this before. And contrary to Senator Hussein's radical idea that there should be one piece of law that takes care of everything in Trinidad and Tobago, that's just not the way it's done. The law is intended to be developed piece by piece as it comes along. So I reject that submission. It's simplistic. And the position is, having amended the Firearms Act after we amended the Bail Act, we are in the situation where somebody has the right to approach the court and say, I fit the bucket of exceptional circumstances. I am asking you, the court, to hear me, and these are my exceptional circumstances. The submission that I make today is that we ought not to define exceptional circumstances. The exceptional circumstances should be left to the judiciary to develop. Why? That's how the common law is developed. Why? That's how the Constitution is described. We don't say in the Constitution what a religion is. We say you have the right to religion. We don't say what privacy is. We say you have the right to privacy. We then put qualifications to those. We don't say what property is. Types of property have developed to include intellectual property. Had we defined property in the Constitution, we would have been left in a stasis, a static position. We say that the Bail Act ought not to define what is exceptional circumstances.
So, Vice President, may I ask you, Attorney General, if the legislation that he referred to from the UK, the US, and Canada, if all of them or any of them defined exceptional circumstances?
None of them
Thank you.
defined exceptional circumstances. It's left to the jurisdiction of the court. I want to make a further submission on the letter of the law. Right now, the Bail Act says that a judge can consider in Section 6 when to grant bail. Section 6.2 says the court should be satisfied that there are substantial grounds for believing the defendant may fail to surrender to custody, effectively may interfere with a witness, may prejudice, may be at risk of his own safety being at risk, or that of a witness, etc. But nowhere inside of there do we get to the matter set out in subsection 3. Subsection 3 says, in the exercise of discretion, the court may consider the following: the nature and seriousness of the offense, the character, antecedents, the defendant's record, the strength of the case, any other factor. Let me put this submission forward. We as a country witnessed, until 2005, we witnessed the judiciary having the right to not grant bail in Trinidad and Tobago. We witnessed that. That's what the law said. from 2005 straight up to 2015, we amended the law. The UNC took it from 60 days to 120 days, and we supported. Why? It was clear that the judiciary, notwithstanding a beautiful piece of law in 1994, consistently failed to express the odium that Parliament directed it to. It was only when the Parliament said to the judiciary, kidnapping for ransom must have the 120 days, which was originally 60 days, and the 1 year, it's only then that the police were given a fighting chance to suppress matters, taking kidnapping for ransom from 100 to 0. So could we have left the Bail Act as it was, Senator Dunarine? I don't know if I've lost you there. I'm seeing your face a little concerned. What I'm saying is the 1994 law was perfect, and it was perfectly inconsistently applied by the judiciary. I have no problem as a member of an executive and a member of a legislature in making observations about judicial decisions. That's what we're allowed to do in this house. We're allowed to develop law as representatives of the people. Because a judge is not a representative of the people. A judge is there to carry out a judicial exercise of interpretation in relation to law. And what we have proved in our country, when you look at Section 6 of the Bail Act, is that it was only when Parliament expressed its odium against kidnapping for ransom that we had a fighting chance. This law, as it's set out, is also subject to more protection. We have in the Bail Act, first of all, Section 9. Section 9 of the Bail Act says where a magistrate is going to refuse bail or grant bail, in the case of refusal, must inform the person and give reasons why he's refusing bail and say, you have a right to go to the High Court and appeal me. Section 10, the magistrate inquiring into an offense alleged to have been committed by a person who refuses bail shall inform him he may apply to the High Court to grant bail. Section 11A, where an application is made to the High Court under 11.1 and the High Court refuses or grants the application or varies the conditions, the accused person or the prosecution, as the case may be, may appeal that decision to the Court of Appeal. So you have exceptional circumstances for the first time included into law in our Act number 17 of 2019. You have the right to appeal to the High Court. You have the right to appeal to the Court of Appeal, both defense and prosecution. You have the example of the 1994 Act not working the way it should have, which saw our country for 11 solid years as a parliament tell the judiciary in what seemed to be unconstitutional circumstances that you cannot consider bail. Let's go now to the jurisdiction of the court. In the judgment that I've handed out, it's Civil Appeal number P351 of 2016. It is between the Attorney General of Trinidad and Tobago and Daniel Saint-Omer. It was also consolidated with the Attorney General and Justin Stuart Charles, that latter one being Civil Appeal S350 of 2016. And I'm reading from the judgment of Gregory Smith, Justice of Appeal, at page 1, and it's been circulated to all of you so you can follow with me. Paragraph 2. Section 5.1 is a statutory affirmation of the constitutional right to bail except as provided for in subsections 5.2 and 5.4 of the same Bail Act. Section 5.5b2 purported to take away the right to bail in certain cases. However, Section 5.5b2 did not mention or seek to affect Section 5.1 above. Stick a pin. Take this bill into consideration. This bill is saying that we are amending subsection 5.3. We are not amending subsection 5.1. We are therefore within the four corners of the Court of Appeal of Trinidad and Tobago interpreting law of similar type which says you have the right to approach a court. And I make this point strenuously as I do to debunk and take off the table for all times this submission that has been coming as a refrain that we are ousting the jurisdiction of the court. We are not in any circumstances most respectfully doing that, honorable senators. And it's here, not only from my reading of the law which I took you through, but also from the dicta which stands as the highest court in our country, speaking to the very kind of law which we're passing now. But mind you, that was law which was very different from ours, because there was a complete ouster of the court's jurisdiction. The court interpreted the law to say 5.1 wasn't touched, you always have the right to access bail. We went further in 2019. Our Act number 17 of 2019 said, hey, put in a subsection 5, subsection 7A. We have the absolute right. Now, what we do, why do we want to tell the judiciary to have a second look at a matter? Put the burden on the accused in keeping with our Constitution, have the accused address on a balance of probability standard, addressing the court, why the court should look twice. You know why? Because I can tell you this. We are at war. Senator Choate made a most outstanding statement to say that this law is reflex and that the country is not at war and that some public official was upset. I reject those submissions. I'm sorry that my learned colleague is not here. I would say it equally to her face as I do on Hansard record. I beg to differ. Senator Choate brings a sensible degree of perspective to us, which I'm grateful for. She is a defense attorney at the inner bar. She lives off of quite properly, and no improper motive here. She lives quite correctly in the domain of law, which says that you can approach these matters that way.
Attorney General, I think Senator Mark is invoking a standing order.
Yeah, Honorable President, 46.6, please.
Attorney General, as you proceed, just be careful in how you present it.
So I am making an observation. I'm rejecting a submission made by one of my colleagues, and I don't think I'm offending anybody by doing that. I'm entitled to do that. It is a legal submission that I'm addressing because the Honorable Senator said that this law was unconstitutional, and I must address that. As a member of the inner bar sitting in the Senate, I must address that. The submission that I make has demonstrated that the Court of Appeal in the Daniel St. Omer matter has sided with me on this issue. The Court of Appeal was not even considering a law which had the equivalent of Section 5, subsection 7A. Section 5, 7A, where we put the exceptional circumstances. And therefore, I do not agree with my learned colleague, Senator Choate, in the submissions made by her on this particular issue, though I find profound respect in her perspective, particularly insofar as she has a line of sight into matters of this as a defense attorney. We must always heed caution. Let us go, Madam Speaker, Madam President, into the very, very dangerous ground that Senator Mark went to. Senator Mark, unrestrained and unbridled in his submission, did something that was exactly done by the last government when we were dealing with the repeal of Section 34. Senator Mark put on record the facts and circumstances of a case, which is the allegation standing in the public domain of possession of parts of automatic weapons, which when totaled up equal to 19 weapons, not 19 parts, 19 AR-15 weapons. And then made the very bold-faced and dangerous submission that we were passing ad hominem law. Put quite simply, the Privy Council, in the landmark case of Lienage came to the fore and said, you cannot pass law to fix one particular matter, a legal case. That is ad hominem. It is directed towards the person. And you can't pass law that is ad hominem. You can pass law for the general purposes of society, but not targeted to do a legislative fix to an individual problem. The last time we saw that kind of danger was when we were repealing Section 34, and then the UNC spent chapter and verse of saying, why the Section 34 matter, the repeal of that law, was associated to the cases in the Piarco Airport inquiry. Fortunately, the Privy Council rejected that argument. Fortunately, the Privy Council accepted my own argument in that debate and said that that law was for general purpose. But I want to say that Senator Mark went about a very dangerous purpose this afternoon, and we have to be extremely careful to acknowledge that this law is for general purport. Why is it for general purport? Let me put it this way. We were asked in the submissions coming from my learned colleagues to give some statistics. Tell us about the law. What has the right to denial or restriction of bail resulted for us? Madam President, what time do I end in full time?
84.
Thank you, Madam President. I'd like to say that I've received from one court alone, and this is from Magistrates Court 4B right here in Port of Spain. I have confirmation in my hands that we have had 11 matters where the denial of bail has happened pursuant to our Act number 17 of 2019. 11 matters. And those 11 matters concerned possession of firearm, anti-gang matters, etc., ammunition, etc. And I'd like to say for the record, as to where we are coming to as a country. In one particular matter, there was possession of prohibited weapon and possession of ammunition. The charge was laid on the 26th of September 2019. The trial on indictment and preliminary inquiry was determined on the 13th of November 2019. Let me repeat that. 26th September start, preliminary inquiry, and that aspect of it finished 13th of November, mere days after. What has been happening is that there has been a rapidity in the hearing of matters, and the other matters are now in the system where none of the trials have in fact started in the 120 days, and 120 days once having lapsed, those people will be entitled to knock on the door of the court. So if you are worried about the statistics coming forward, there are exactly 11 matters in Court 4B, which is where we deal with the gun matters. Of those 11 matters, one was heard and completed in a matter of 2 weeks flat. The others have not even started in the 120 days, and therefore their time will result in them knocking on the door. That feeds the allegation of propriety, of proportionality. We have had the statistics of the possession of prohibited weapons. We have had the statistics showing that we have machine guns in place in our country. You know, I listened to the members of the opposition, Senator Hussain and today Senator Obika, talk about locking down the borders. I heard Senator Hussain do the usual genuflection to the leader of the opposition, all hail Kamla Prasad Bisesa. She got back $1 billion in the arbitration claim for the OPV matters. The relevance to this, apart from answering this submission, is that when we lost the offshore patrol vessels, we lost the ability to man our maritime borders. I can tell you now as Attorney General, having taken over that portfolio from the last two Attorneys General, we didn't win any $1 billion in the arbitration proceedings. I can publicly say that my attorneys in that matter, Trinidad and Tobago's attorneys who acted in that matter, said, it is only because the Brazilians agreed to buy the vessels, which the UNC said were not good, that we got the credit of the $1 billion in not having to pay it. So let me debunk this foolishness that is being spread as fact, Madam President. We didn't win any $1 billion award. We were lucky that the Brazilian Navy, to protect their coastlines, took the BAE vessels, and you know what they named the BAE vessels? Trinidad-class vessels. The Brazilian borders are being patrolled by Trinidad-class vessels. And I heard Senator Hussain talking about the AG's office and somehow me being responsible and putting it on the record that we lost a particular matter where there was a default judgment. I'd just like to say that the default judgment matter handled by the Solicitor General's office without the Attorney General's involvement is a matter under appeal. But I'd like to put on the record to Senator Hussain, who apparently knows it all in connection to helicopters, that he needs to go off and do a little bit more work. You see, Madam President, I can tell you in 2 matters that I have personally negotiated and are now settled, and they are in reference to the UNC's acquisition of 2 helicopters. We were facing claims of $32 million US. You know why? In one case, the UNC bought a helicopter and paid for it for an entire 5 years, and the helicopter was never sent to Trinidad and Tobago. So we paid 5 years for a helicopter that stayed in the manufacturer's hangar. In the second case, we actually had a helicopter sent to us, and we couldn't get the airworthiness certificate done. I am very pleased to tell you, Madam President, that I negotiated those claims down to $6.5 million, down from the $32 million US that the UNC left us into. So I respectfully say to Senator Hussain, do some homework and get your facts right before you try to pelt stone on other people's house, Madam President. Madam President, it's true, as Senator Sipasad put here this afternoon, obviously the law can't work by itself. It is true that under the last administration, and I genuinely mean this, all building and maintenance facilities at the judiciary were shut down. They were shut down because we were supposed to have administrative complexes built for courts. And as you know, not a single court opened in Trinidad and Tobago. Senator Sipasad has made the submission that we ought to have specialist courts for gun matters. I will remind honorable senators, that's why we passed the Criminal Division Act. And Section 24 of the Criminal Division Act allows the Chief Justice to establish specialist courts. But I will put onto the record now that it is this government that has opened 2 court buildings in the children's courts, one in Faizabad, one in Port of Spain. We have opened the family court in Tobago, and right here where we sit in January of this year, all of the civil courts will be brought to this particular place, including the appellate division, and we will yield 70 criminal courts in Port of Spain. The magistrates court in San Fernando is about to go out for full tender. The court in Princestown is about to be completed in the course of this week from cabinet approval basis. We're dealing with courts in Arima, so we accept, Senator Sipasad, the recommendation that we need more than just the law. And that is why I'll remind honorable senators that we amended the law to allow for the movement in the number of judges from 36 judges to 64. We as a government introduced the concept of case management under criminal proceedings rules. When we came into office, there were 2 masters. We have 14 masters today, and we're about to take on 10 more masters. So we already accept and have implemented criminal proceedings rules, divisions of court for family and children, divisions of court for the criminal arena, computerization of the computer court, of the magistracy, introduction of court mail, introduction of electronic payment and electronic filing, maximum sentence indication, preliminary inquiries, soon to be abolished. There's one more tweak to do by way of an amendment, which will come in about a week or so to this Parliament.
Attorney General, you have 5 more minutes.
Thank you, Madam President. That will come to this when we this year move by the introduction of the electronic payment side, the 104,000 cases from the magistracy, we're treating with that. But this law, honorable senators, this law is intended to treat with the war that we are in. Last week we saw a member of parliament in the opposition robbed at gunpoint. Honorable members in this very house know what it is like to lose someone to crime. We are witnessing children murdered in gun spray from automatic weapons. We are witnessing state witnesses with automatic weapons mowing them down. The very judiciary that has to interpret these laws, I can tell you, the judiciary, when they are exercising the criminal jurisdiction, are protected to the hilt. Security outside the home, security in the car, security on the way to work, security standing outside. The average citizen doesn't have that. The leader of the opposition runs with 2 or 3 cars flagging, the detail running behind her. They don't operate with that. And therefore, when we say Trinidad and Tobago is at war, if you ask, as was done in the newspapers, when you ask, as the newspapers have, and I will say I drive in 1 car, unlike my predecessor that had 4 follow cars behind him. I drive in 1 car. And I can tell you, Madam President, notwithstanding Senator Mark's obscene histrionics.
Senator Mark. Continue, Attorney General.
Notwithstanding extreme histrionics, the vox populi, the voice of the people taken from the newspapers that asked San Fernando and Port of Spain whether they think Commissioner Griffith was correct in asking for prohibited or weapons of war type weapons to be subject to no bail filtration, not prohibition. Every single person that appeared in the newspapers said yes. What can I say? If this House chooses not to support this law, I'm sure that the record will reflect the reasons why. I believe that our society has already had the exercise on this law in by far more draconian circumstance. That was in the amendments between 2005 to 2016, which was a complete ouster of the court's jurisdiction. For 11 years, that law stood on the books of Trinidad and Tobago and collapsed in 2016. I genuinely believe that the Parliament has the ability under its legislative regime to create law for the peace, order, and good governance of our society, as Section 53 of the Constitution permits. I genuinely believe that we have the right to tell the judiciary what we consider the people ought to have. This law is proportionate. This law is measured, Madam President. I believe that we have the ability to support it. For the record, the sunset clause applies. The law will collapse when Act number 17 of 2019 collapses, because we're amending Section 3. And therefore, the sunset clause goes there. There is the proportionality in having 3 bites at the cherry, magistrate to consider yes or no, High Court to be told yes or no, and the Court of Appeal to hear the appeal on that. You end at the Court of Appeal. So we have due process protection. We have the right to access the court in Section 5, subsection 7A. I ask you to reject fear. I ask you to reject the war that is being told cannot be won. I ask you to give us and our law enforcement agencies a fighting chance. This is not intended to be a punishment by way of sentence. It is within the parameters of bail, as has stood the test for 22 years in our country. I beg to move.
Honourable Senators, the question is that a bill entitled An Act to Amend the Bail Act, Chapter 460, be now read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Amend the Bail Act, Chapter 460.
Attorney General.
Madam President, in accordance with Standing Order 66-1, I beg to move that a bill entitled An Act to Amend the Bail Act, Chapter 460, be committed to a committee of the whole Senate, forthwith to be considered clause by clause.
Honourable Senators, the question is that a bill entitled An Act to Amend the Bail Act, Chapter 460, be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. Senator Mark, I understand that you have submitted some amendments. And honorable members, the amendments, I am told, should be here very shortly. So I am going to suspend for 5 minutes. Yes, Senator Vera?
Chair, thank you. I'm wondering, could we not use that time while we await Senator Mark's amendment to have an important discussion? Because it's a very short clause, but I think there's some very important points that we may wish to consider.
So you mean as we sit in committee, we can?
Yes,
Sure,
yes,
no
please.
problem. Yeah?
And if I may start off,
No, well, let us, we have, we have two clauses that I think we can, yeah.
Clauses 1 and 2.
Honorable Senators, the question is that clauses 1 and 2 stand part of the bill. The question is that clauses 1 and 2 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 and 2 now stand part of the bill.
Clause 3.
The question is that clause 3 stand part of the bill. Senator Vera.
Very General, through you, Chair. I want to come back to the sunset clause. I think it was an important point that was raised. It's quite clear in the 18 of 2019, not 18, 17 of 2019, I'm looking at the Firearms Amendment, that this act, which is 17 of 2019, shall continue in force for a period of 3 years. Now, after 3 years, in 2022, this amendment goes by the wayside, but the original Section 5 would remain. And the amendments we are making to Section 5 today, arguably, would also remain because this bill does not have a similar sunset clause. So perhaps you're right. Maybe one can argue it either way, but I would think out of an abundance of caution, you may want to consider the sunset clause if we are going forward with this.
I thank the honourable senators, all who raised this particular point. Senator Mark raised it, Senator Vera raised it. I can say that this was actually tested when the St. Omer case came up, because by 2016, all of the laws cascaded. And all of the amendments from 2005 straight up to 2015 cascaded, whether they recited sunset clause or not, because the original sunset clause applied. So we looked at it. We're absolutely confident that the amendment to subclause 5.3, as this bill proposes, is to be amended, will automatically fall apart. Because what happens, assuming that I agreed with you, and that somehow we needed a sunset clause because there was a risk that the new sub A, B, and subclause A, C would still somehow stay. The original 1994 version of subsection 5.3 does not permit that, because you're back down to 3 strikes, 15 years, no offense happening within 15 years apart. So it was tested properly in court already. If you wanted, out of an abundance of caution, to put in some form of clause that said that we should harmonize it with Act number 17 of 2019, I have no objection. But I looked at it and I'm confident of that, but again, I have no objection to even doing that.
So, AG, I accept what you say. I just wanted to have it on the record.
Sure.
I think the more important concern for me, and I have looked very closely at the St. Omer case. I thank you for providing it. When we look at the other sections, they all involve a clear risk to society. Accused persons who have prior convictions, accused persons who have pending charges, accused persons who have were caught in the act of committing an offense with a firearm. And all along, it's not just the offense, but it's this add-on. Here now, prohibited, being in possession of a prohibited weapon. No pending charges, no prior convictions, none of this. Now, so right away, the question is, should they not be treated differently to these real risks and threats to society? That's one thing. The other thing is, in the St. Omer case, a woman was held for 5 months before she was able to get jail. It's true, and in that case, this was even when the sunset clauses had been gone by the wayside. She's exactly the sort of person that we are concerned about. Unblemished record, first offense, just happened to be in the wrong place at the wrong time. Now, in St. Omer, what I gather they're saying is, even though we are giving us statutory discretion to deny bail, you can't oust Section 5(1), which says you have a constitutional right to bail. But look what happened in St. Omer. She bounced a wrong magistrate judge. It took years to reach a court of appeal for her to get a just decision. And it also took many months for her to be given bail. So what I'm saying is, even if you're right on the law, that theoretically you will be upheld at a high court or in the court of appeal, there is still a very real risk that a person who is innocent could be incarcerated while they go through all of these motions. Isn't that disproportionate? In the St. Omer case, it was clear that, and you said it, 1994 was inconsistently and wrongly applied by the judiciary. The way the wording of this section goes, I would see most magistrates saying, I'm not granting you bail. And then you're going to come down to the question about what is the exceptional circumstance. Now, I agree. I understand what you're saying, that this is an evolving part of the law, and it's arguable that you can be. But the concern we have, and it's a very real concern for me, is how do we protect, how do we guard the St. Omers from going through a similar situation?
Sure. May I? Thank you, Honourable Senator, for being very clear on the mischief that you intend to guard against. I can do two things. I can address proportionality, which I will, and I can also address distinguishing St. Omer from the current situation, because they are not equal. In the St. Omer matter, we did not have the equivalent of Section 5(7)(e), the exceptional circumstances. So in St. Omer's case, she could not knock on the door to say, look, I'm an exceptional circumstance. What St. Omer acknowledged was that she had the right to approach the High Court and the Court of Appeal. Unfortunately, that due process worked out and proved that even though she was brought in, remember, it was her right to access bail, not the fact that she was charged. So she may still have a matter before the court, but she accessed bail. So St. Omer proves, number one, the system works. Right to High Court, right to Court of Appeal. In those instances, they took a few months, but they worked. Second aspect, St. Omer is to be distinguished because St. Omer did not have Section 5(7)(a), which says that you can approach the court notwithstanding the restrictions of 120 days and 1 year and anti-gang, etc. You have the statutory underpinning, let alone constitutional, because St. Omer turned on Section 5(1) and the Constitution. We went further. We put in Section 5(7)(a), which in the statute says you can knock on the door and argue what you consider to be exceptional circumstances. So in fact, we've not only gone magistrate, High Court, Court of Appeal, we've added in the horizontal exceptional circumstances in the magistracy. On the issue of proportionality, we are in a situation where the Parliament is narrowing down the playing field and the war. We are saying, listen, our society is at a place right now where a court should look at you in a jaundiced way and ask you to explain why you, who are alleged to be in possession, of a weapon of war or deemed to be trafficking in weapons, you don't have one weapon, you have two and more, why you should not have to explain yourself to a court. Because we're not removing the court. We're not removing the jurisdiction of the court at all. We've reaffirmed the jurisdiction of the court. And we believe that the proportionality is to be found in the state and condition of Trinidad and Tobago. Has it worked in the past? It worked for kidnapping for ransom. I'd just like to remind that if you look at what is scheduled as the offenses captured under the bail amendment bill, on a charge basis, a conviction charge basis, or having possession of a weapon in the course of conducting an offense, carrying out a offense, they're actually all very serious matters, I don't think that we're outside of proportionality to add possession of an automatic weapon or a grenade or a missile as opposed to a missile.
I have no problem with that in principle. But you see two things. Easy to be framed with possession of a prohibited weapon. A grenade is a small thing. And the other thing is, again, when I come back to the exceptional circumstances, if I were to take a conservative interpretation, everything I see when it talks of exceptional circumstances, conditions required so as to alleviate or mitigate unforeseen or unconventional hardship. The court's interpretation of exceptional circumstances has traditionally been narrow, usually relating to medical circumstances. Justice Rouse made clear that exceptional meant just that. The usual consequences were not sufficient to displace. Exceptional suggests that the situation is extreme. Most involve personal circumstances like medical and mental. So I could really see somebody being caught on the wrong side of the law, even though innocent, and exceptional circumstances not availing them.
So, Attorney General, Senator Vera, I just want to make an interjection. I think the amendment proposed by Senator Mark has now been circulated, so all members should have the amendments. I will allow the Attorney General to respond to Senator Vera, but then we will move to deal with the specific amendments that we have before us. Okay? Attorney General.
Madam President, Madam Chair, the fact is that our policy as a government is effectively that we are comfortable with a court having the supervision under Section 5.1 as to why your bail ought to be considered, which we have not touched. We're comfortable with the court having supervision under Section 5.7a, which is this backup clause of exceptional circumstances. We believe, from a policy perspective, that our society has to be assisted and that anybody in possession of an automatic weapon or who is on a charge for trafficking in weapons ought to be treated differently. We can only do our part. We can only do our part. We can add our voice to what we prescribe as a remedy. We have distinguished ourselves from every single law to treat with bail for 22 years. Act number 17 of 2019 does not have the construction that all other bail amendments had. None of them had it. St. Omer, all of those cases were built upon a complete ouster of the court's jurisdiction. We separated ourselves by allowing Section 5.1 to prevail and also the Section 5.7e. If this Senate genuinely feels that it can't risk telling people that they ought not to have these things in their possession, if this Senate is comfortable on constantly telling us that Singapore is the model of success and we ought to follow Singapore. In Singapore, if they find drugs in your suitcase, they don't even ask you, they execute you. In Singapore, if you're found in possession of an automatic weapon, you are subjected not only to no bail, but to execution and death. So we very much have a love and an admiration for jurisdictions that have very tough approaches on gun laws and on drugs, etc. On this occasion, the question is, where do we stand? And that isn't a threat. That is a philosophical discussion that obviously we have to have in balancing mischief and in protecting rights.
Senator Vera is giving me a most appealing look. So I'm going to allow Senator Vera to close off this discussion as we move into the discussions on the amendments. Appealing.
Thank you, Chair. Honorable AG, we get it. We understand. We are equally, I must tell you, we are all torn. That comes out in the debates. We know what you're trying to combat. We want to support the legislation. But we are in a society where we are also painfully aware of how many innocent people have been framed and set up. And so what I'm saying is, if we can get some comfort, some stronger comfort than having a mayor having to bounce around the court and to test exceptional circumstances, you will get the support you want, but we are torn.
Madam Chair, I know you said that you would close off, but he raised a very important point, if you would allow me. The Prime Minister instructed me, let me repeat that, the Prime Minister instructed me to draft a framing charge. I'm working on it right now. The bill has been laid in the Senate already. We're proposing an amendment to the several law enforcement agencies, Trinidad and Tobago Police, it's a miscellaneous provisions law enforcement bill. So we're proposing to introduce a charge, and I'm giving the undertaking now that there will be introduced in the debate next week an amendment to that bill to introduce a charge, a criminal charge for framing. I already have the first draft. The drafter is actually sitting on my left right now. Whilst we were sitting here, I was going through various iterations of the charge, and I've been given that instruction to present that by way of an amendment to this Senate for consideration.
Madam Chair, how does what the Attorney General is saying help us? I don't understand the relevance of that in the context of what Senator Vera is advancing.
Do you wish to respond?
I thought that I was just rhetorical. Because,
Right.
Yeah, I just
So-
didn't understand Senator Mark to be asking a question.
I think at this stage, because this philosophical discussion can continue, and I think we should go into the specifics. So, Senate, there is a proposed amendment circulated on behalf of Senator Mark. So, Senator Mark, perhaps you would like to speak to your amendment.
Yes, thank you very much. Madam Chairman, we are very clear, and we have said it in our contribution, that we believe that this new offense, trafficking, that the government has introduced is or does require some balance. And therefore, we do not believe a person who, for the first time, without any conviction or pending charge and merely in possession, should be denied bail as a matter of course. And therefore, we want to safeguard the rights, particularly of the innocent, in circumstances that can prevail and, from examples, have prevailed. And it's against that background we are proposing for the consideration of the government that we amend Clause 3 by inserting after the words Firearms Act a new subclause, AB, the words has a pending charge or previous conviction for possession of a firearm, ammunition, or prohibited weapon, or an offense listed in Part 2 of the first schedule. Madam Chair, we are also going further because the context of a prohibited weapon is in the legislation, and we are also introducing a new subclause AC. The words has a pending charge or a previous conviction, and the words are clearly outlined. And Madam Chair, the purpose of this is to avoid innocent people and people who are caught in the net for the first time. Madam Chair, you will recall when we were debating this matter, we got a number of examples as it relates to the Firearms Act. You can have 5 persons in a place and 1 person has a weapon, and all persons in that home goes down, all the persons, and they are charged. And many of those persons, Madam Chair, may have had a very clean record. They would have had an unblemished record and a clean past. And therefore, we believe as legislators, we need to protect the innocent from the guilty. And this is why we are submitting this amendment for the consideration of the Attorney General.
Thank you, Madam Chair. It's in relation to my overall interpretation of the clause we're discussing, and it's out of an abundance of caution because of my absolute ignorance of legal interpretation, so I apologize for that, but also in relation to part of what Senator Mark is proposing in the amendment. And just for my clarity, Attorney General, is the accused, does the accused have instant access to the courts? As you said, the judicial process is not taken out in your submission without having, because I heard, I got some advice from several different legal counsels. It was quite confusing because of the handshake between the Parent Act and these proposals and the convoluted nature of some of the language. So I was a bit lost in terms of my understanding. Does the accused have access to petition the judicial officer immediately upon being charged? Or is there a delay of any kind in that process? That's the first part of the question, if you could respond to that. Is there any absence of, or does the accused have to serve 60 or 120 days without bail before having that access to the judicial officer?
Sure. Thank you. May I respond in reverse order to Senator Richards first? First of all, and you've really come upon a very important area for clarifications. I thank you for allowing us the opportunity to do that. First of all, there is no requirement for the accused to petition. In other words, then it's never going to be for the accused or the defendant to ask for it. Because the law as it is that the minute that you're arrested, you must be taken before a magistrate within a reasonable period of time. Once brought before the magistrate, there's a process that is invoked. Sometimes that process involves, particularly in serious matters, the DPP considering whether you ought to be there or not at all. I'll give you an example. 7,000 people were arrested under a state of emergency. 7,000 people got out from under the state of emergency. The DPP basically returned to court every single time and said, I will not volunteer a charge because there's no evidence in relation to these matters. So that's an extreme example of abuse of the people of Trinidad and Tobago in the circumstances of that state of emergency. That is now amplified in terms of protection by what we call the remanding cycle. So you are bound to be brought back before the magistrate in the remanding cycle. If no date is given to you, it was originally 8 days, it went to 28 days. So you must come back before the court every 28 days. In any event, where the accused or defendant has a right, is the right, which is a constitutional right for habeas corpus. So that is to bring the body. So the accused always has the right, where the police have not done what they should do by taking you to the court, to have you subjected to the magistrate's consideration or judicial officer's consideration, which is your constitutional right to bail. If that doesn't happen, you can knock on the door of the court immediately and say, bring the body, habeas corpus the body. So there is the existing framework of law where you must be brought. And to answer your specific question, no, you don't serve 60 days loco parentis, anti-gang exception, or 120 days for all other schedules. That's not it at all. You must always be brought to court, subjected to the court's jurisdiction. The court may adjourn the matter for consideration of tracing or other matters, etc. You are bound to come back to court. If they miss the day, every 28 days you must be brought back before the court, etc. So there is that existing safeguard on that point. I hope I've answered your question from that perspective.
Well, you've answered the question, but you've opened a hornet's nest. With my greatest of respect, because if I am in a car for a scenario, for example, I'm trying to be succinct, Madam President, and the car is discovered, stopped by police and discovered with an AR-15 or a maxi taxi, and we're all 20 of us taken down and charged under the provisions of this, and I fully support the seriousness of it. And the process that you've clearly outlined kicks in, and 28 days passes, and another 28 days passes, and I'm trying to prosecute my case to show that there's legitimate reason why I am not to be found in the ambit of this. My liberties are being thwarted, and that is of great concern to me. And as we said, part of our job here is the protection of the citizenry who should not be subject to this.
There is confusion here. Let me assure you, in any circumstance, if we didn't pass this law at all, that would happen. Once you are in possession of a firearm under the Firearms Act, and you are absent of a lawful excuse, which the burden is on you to prove, and it's done so in the course of a trial, exactly what you described would happen. Why? Under the scheduled offenses, possession of a firearm is included in the Schedule 2 offenses, except for Section 6. So that is how the whole system works right now. What this law is proposing to be introduced is that the court will, for the first time, ask you to address your situation before the court in a slightly tighter environment. Show exceptional cause why you should be granted bail. But that is not to say that everything that you just described doesn't happen in any event. So that hornet's nest, the grub that get taken down, that happens every day. Every day in our system for dangerous drugs, where there is a lack of a mens rea. It's a qualified mens rea, meaning intention to have possession is not necessarily the case. That's been fine-tuned now to say that you must have actual and not constructive possession, meaning you must know about the thing. And then secondly, for firearms, etc. So that it happens right now. Madam Chair, I didn't get to address Senator Mark. So don't address Senator Mark just yet, okay?
Senator Sobers, I think, has for the longest while been trying to make an intervention.
Thank you, Madam Chair. Through you, AG, just a couple of things with respect to this particular amendment. Now, in terms of your response to Senator Richards, it really isn't the case, actually, that if it is there are 10 persons in a maxi and a firearm is found, yes, all persons may be very well arrested. But if there are persons who, at the point in time subsequent to tracing, they don't have any criminal records, as it stands right now, they would be entitled to bail. Based upon this particular piece of legislation, if it is enacted, they will not be entitled to bail if the firearm in question is the AR-15. The difficulty is, I appreciate then that we have this exceptional circumstances situation. And in terms of practice with respect to driving under the influence, there's a very large area of law in the UK where they deal with exceptional hardship principles, wherein if someone has their driver's permit taken away from them, they can demonstrate to the court through exceptional hardship principles why that license should be returned to them. And in terms of my debate, my contribution, I indicated that we should consider something like that. The problem is, when I listened to what you were saying just now, and even to Senator Vera, it appears, and also Senator Hussein, the exceptional circumstances that the legislation is encouraging appears to be very narrow and specific to the individual. Because as I was explaining to Senator Hussein, we already utilize some form of exceptional hardship when we are applying for bail. So we refer to a dependent that the applicant may have who would suffer some type of prejudice if he is not currently out on bail. But if it is exceptional circumstances, is different from that particular position and is specific to the applicant, then it is an extremely high threshold that I don't think many applicants would be able to pass, if any at all. And then lastly, please, Madam Chair, I could recall when the debate was ongoing on the last occasion, not last week, but before, I believe it was Senator Choate who indicated that you would have we have used all different types of examples, but a very good example that was used, I think, by Ms. Elder, senior counsel, was a situation where an individual would have been found with 2 derelict firearms that he may have had on his property from time immemorial. If with respect to this particular framework, a person like that who would have had no previous or pending matters, and for whatever reason his house would have been searched and those derelict firearms would have been found, he would fall under the trafficking provision, and that individual would not be granted bail for up to 120 days pending the starting of the matter. And I think those issues, coupled with what has been said by Senator Vera and others, is what we are really grappling with respect to this particular piece of legislation. One other thing, sorry, Madam Chair, and in terms of the habeas corpus point that was raised, Honorable Attorney General, the difficulty is, and to also assist with respect to Senator Richards, a habeas corpus application is not something that is easily made by an individual. An individual will have to get an attorney who has to make an application to the civil court, high court, for them to access the court for the body to be produced. So it's not as simple as put on the record, respectfully. Grateful.
Yes, Madam Chair. Madam Chair, what we're really trying to decide is where we as a society decide the line should be drawn. We in the government are saying that there is a war afoot. We have the phenomenon of automatic weapons that are in fact killing people. There will be 100 or if not 1,000 examples we could give today of where somebody would have some hardship in the law. I hear Senator Hussein saying $10,000 to get a lawyer. Well, what about the bailer? There's a monster that we're not addressing in this country of bailers, professional bailers. Everybody says it's illegal and every lawyer goes outside and looks for a professional bailer. Yeah, I can say whatever I wish to say, Senator Hussein. I can say what I wish to say. I can say, Madam Chair, I wish not to be interrupted. I can say what everybody knows. And what I can say in deciding this particular position is we believe, from a policy perspective, that the law ought to be that you should be extremely hard-pressed in circumstances with weapons of war or trafficking. We believe that there is a due process provision that is allowed, whether it is difficult or cumbersome. When anybody is in difficulty with the law, it is always difficult and cumbersome. I accept the general philosophy of hardship provisions, which you have very, again, always commendably put onto the record. I think that that is already a feature of the law in your submissions that you can give, in the Section 6 submissions that you would give before a court that considers bail. You are not, in any circumstance, I wish to draw a distinction, ever excluded from accessing the presentation of your bail. The question is, what will exceptional circumstances mean? Or whether you fall under Section 5.1 in accordance with the St. Omer principle. The amendments proposed by Senator Mark, for instance, are already captured, in essence, in Act number 17 of 2019. So if you're going to put that you must have a previous, let me call it that, whether it's a previous charge or a previous conviction, well, that's already what we passed in Act number 17 of 2019. So the recommendations made by the Honorable Senator Mark are otiose, they're superfluous, they exist already. You could consider it in that sense. It can probably be done by way of an amendment to the schedule as opposed to the Act itself, because I see you saying no. but allow me to at least present the case just for a moment. Senator Mark, under the specified offenses in Part 2, what we do have is in letter I, an offense under the Firearms Act, other than under Section 6.1 or 6.2, which is punishable by an imprisonment for a term of 10 years or more, or an offense under Section 8, 9, or 10 of that Act. So it is at that point that the inclusion of Section 9A might be considered for the trafficking in firearms position. Unless I hear something further on that particular proposed amendment that may change my mind, that's where my mind is for now.
No, before Senator Hussain, you wanted to say something?
Thank you very much, Madam Chair. Let me address Senator Mark's proposed amendment. Madam Chair, what Senator Mark has attempted to do is create a level of safeguard for all of the dangers that have been outlined by the senators on this side of the House. And the Attorney General said that, well, this is a odious amendment and it's redundant. I don't agree, simply because currently, as the bill is presented, is that as soon as you're charged for the first time with trafficking or simple possession of a prohibited weapon, there's no bail. What the amendment attempted to do is now create a safeguard so that bail can be granted if someone is charged for the first time for a trafficking offense or possession of a prohibited weapon. So that is the first safeguard that we're putting in here. The second safeguard will, of course, be the right to apply for bail under the exceptional circumstances. Now, let me deal with the exceptional circumstances. In criminal law, this is one of the most, if not the highest threshold in which an accused person will have to reach before the court can grant some relief. And if I may just draw an example to what the court would have used for exceptional circumstances, there's something called abuse of process. So therefore, when someone believes that their trial has been delayed for far too long, they can apply for the court they can apply for them to be discharged because there's an abuse of process. There are case law that suggests that delay can be exceptional circumstances. For example, there are cases in Jamaica where the delay was exceptional in terms of being 12 years before you had a trial. And the court came back and said, well, no, that is not exceptional circumstances. There must be more. You must show some more level of hardship. Now, Madam President, in this particular instance, we are exploring here as a parliament what would be exceptional circumstances, and nobody could agree, and yes, we agree it's a judicial discretion. But you have to remember that the persons who will be captured under this law, they are automatically denied bail as soon as they're charged. If this bill is not passed, what stands is that, for example, if 5 of us are in a vehicle and the police finds 2 weapons in the car, that's a charge for trafficking. Now, at the hearing of bail, if 4 of us never had any pending matters or any previous conviction, the likelihood of 4 of us having good character will get bail. But if there's one person there who probably had some previous or a pending matter, well, the court has the discretion to not grant that particular person bail. And what we are doing right now is removing that particular discretion from the court. Madam President, I believe that we need to put the safeguard here with respect to that in terms of protecting innocent people who can be caught under this particular amendment. I thank you. And let me just correct the record. 7,000 persons were not detained under the SOE.
So if
It
I
was
could
more.
just ask.
Probably more,
Senator-
millions spent to get them out.
Senator Vera and Senator
Boy,
Richard,
this has it wrong.
are you going to,
I'm seeking the amendment.
I know, but are you speaking anything further to the amendment, or are you echoing what has been said before by other senators and by yourselves as well?
No, I think it's different.
Okay, Senator
Same
Vera and then
members are different.
Senator Richards.
Sure.
That could be.
Chair, I would support Senator Mark's proposed amendment because I do think it will provide a safeguard for the first-time offender, and it is also consistent and in line with the other parts of Section 5, when you go through Section 5, it's quite clear, under Section 6 of the Firearms Act, and the person has a pending charge for possession of a firearm. You go down, listed in Part 2 of the first schedule, and has a pending charge for an offense specified in said Part 2, or the person or any other person involved in the commission of offense used or had in his possession a firearm or imitation firearm. But when we come to these new amendments, no qualification. Senator Mark's qualification, I think, does support and is consistent. The other thing is, I would remind the Honorable Attorney General that even if it's a first-time offender charged with a prohibited weapon, the court still has a discretion not to give bail. And if the court gives bail, the prosecution still have the option to apply for the bail to be revoked. So we have to look at the thing, as you like to say, in the round.
Well, Attorney General, I think Senator Richards
Yes.
has a similar view, and then you can...
Yes, just
Of
I
course.
want to echo Senator Vieira's point that I support Senator Mark's amendment. And I just want to put in a record, with the greatest of respects, Attorney General, through you, Madam Chair. I am dying to support this because I understand the seriousness of it. Well, I support this strongly. I support it. I take your counsel, Madam Minister. I support this strongly because of the seriousness that I feel convicted about. But I also have to balance protecting that one or two innocent people who will have to go through that cumbersome system and have their lives traumatized, if not destroyed, and the lives of their family. That is the balancing act that I am torn with. So it's not that I don't want to support it. I want it on the record. I just want to balance people's rights, and especially the rights of the innocent people.
Madam Chair.
Attorney General.
Thank you. I thank honourable senators. Let me explain why Senator Mark's submission is not necessary. And let me point it out in black and white. And then let me just summarize what has come to us and what our position is. Senator Mark's amendment is effectively has a pending charge or previous conviction for any one of these two things. Everybody has a copy of the Bail Act as amended that I provided to everyone. As amended by Act number 17 of 2019, you will see in subsection 3, it's on page 2, it's in blue, subject to subsections 2, 4, and 5, a court shall not grant bail to a person on or after commencement who is charged with an offense under section 6 of the Firearms Act, and the person has a pending charge. Okay, so that's the lowest of the hurdles. Senator Mark is saying, apply the same formula. Pending charge, if you come for a charge with possession of more than 2 firearms, that's the trafficking, or if you come with a possession of an automatic weapon, and you have a pending charge, you're good to go. I'll take you now to Section 6 of the Firearms Act. Section 6 of the Firearms Act is all-encompassing. Section 6 says, subject to subsection 7, you can only have a firearm if you have an FUL. That's subsection 1. Subsection 2 says nobody except qualified people can have automatic weapons, basically, prohibited weapons. Police officer, defense force, SSA, etc. So the automatic firearm, the prohibited weapon, and the more than 2 weapons are all caught within the definition of Section 6 of the Firearms Act. What is in summary being said by Senators Richards, Vera, and the opposition is that you don't want anything other than 2 strikes on charge. That's the lowest of the standards. Lightning must strike twice on a charge for firearms. That's what you're in summary saying. The government is saying that we consider that the time in the war that we're fighting right now to consider 1 strike, lightning striking you once for the very narrow position of an automatic killing weapon or 2 or more weapons is now. We're saying that this country is not reinventing a heavy hand because we did it for anti-kidnapping and we did it for anti-gang. The opposition supported no bail on the first occasion for anti-gang. Because we went down to one strike, as the St. Omer judgment has it. So Senator Marks' amendments in effect say, forget the inclusion of automatic, prohibited, etc. What he's really saying is you must have at least a charge. That's what he's saying, charge. Where we are drawing a line and asking the Senate to consider, and it's either the Senate has an appetite for it or not, we are convinced based upon the data and the fight that we're fighting that we need this law. We're convinced that based upon how the anti-kidnapping law worked and how we fought that scourge down, we do that. Because I'll tell you this, as it comes to us at national security and at the executive, we're being told that people who are released go out and commit further murder. We are not blocking the right of access to the court. We're putting it in the sharp context of that filtration of exceptional circumstances in subsection 5, 7A of section 5, or in section 5.1. So, in essence, Madam President, what we're really down to right now is a philosophical difference. I think that I understand clearly that Senators Vera and Richards and the opposition have said that they don't want one strike. You're not up for that game. You believe that people must trip twice. Our problem is tripping twice with weapons of war is a problem for the government and a problem for the society, a problem which the police, let me put this clearly, the police in Trinidad and Tobago and the Commissioner of Police have come out and said that there is a problem with automatic weapons, killing machines, which we have seen statistically. I've given you the statistics. At the end of the day, obviously, we can agree to disagree. We can respect each other in terms of philosophical differences. I understand the passion of all members, in particular Senators Richards and Vera, and the opposition bench in saying what they wish. From a political perspective, I think that it is duplicitous for the opposition to be saying today the opposite of what it said in the period of the 5 years and 3 months that they were in government, but that's the opposition's rule. They're allowed to do that, they do it consistently. So I think that the government's position is that we have genuinely tried to allow for a balance. We have not restricted, as other laws have, the right to access the court. It's preserved in Section 5.1, in Section 5.7a of the Act. We believe that the time to draw the line in the sand on the war is now. We say that you should not have in your possession weapons of war, and you should not have more than 2 weapons. That is what we see. So, Madam Speaker, Madam President, I don't know if there's much more to discuss.
Okay, so, Senator.
Just one.
Sure.
I just would like, with your leave, to remind my Honorable Attorney General of a statement he made on the 12th of June, 2019, at the committee stage. And I quote, "Move away from you are under possession. First time, you are out, and modify it to charge. Would that allay the difficulties?" And all the senators said yes. Yeah. And the Attorney General.
I acknowledge I said that. We had not introduced trafficking in firearms or weapons of war, which we did in the Firearms Act after. So we agree to disagree.
So, yeah. Honourable Senators, I think that we have exhausted all discussions on this, so I am now going to proceed with putting the proposed amendment to the Senate. No, we just didn't. Mark, Attorney General, Senators Vera and Richards, everyone spoke to the second part of Senator Mark's Clause 3 amendment, because he did ask that Clause 3C be deleted. Yes. And everyone is clear on that as well. Yeah. All right? So, Honourable Senators, the question is
Madam
that
President.
Clause 3 be amended.
Madam President, Clause 3 sub C, we didn't have any discussion on that, please. that deals with whether or not that your trial starts within the 120 days that you're denied bail until the completion of the matter.
We didn't discuss that.
Yes, please.
We didn't discuss that. And that is a very serious one.
Madam President, if
Senator
you,
Mark, it is your amendment that was
doesn't know that.
proposed by you.
Yeah, but
And so are you saying that you are handing over the deliberations to Senator Sobers on clause 3,
yeah, for this one.
3C? Senator Sobers, yes?
yes, Madam President, Madam Chair, when you look at clause 3C in particular, why we are saying to delete clause 3C, the way in which section 7 of the Bail Act is currently, 3A, if you are arrested and you are denied bail for 120 days, if the trial starts within 120 days, but the trial does not finish within a year, this widens the ambit now to catch persons who would fall under the trafficking of firearms, as well as the persons who would fall under being in possession of prohibited firearms, that they will also not be granted bail if the matter is not concluded within a year. And we were saying that we wanted that particular new amendment to be deleted, and it stands as it is that only persons who are charged under 3A would fall within that, and not persons who would fall under this new 3AB or 3AC. So basically, if 3AB and 3AC are allowed, then we are saying that if you are denied bail for up to 120 days, your matter starts within your 120 days, but your trial is not completed within a year, then those persons under 3A and 3AB and 3AC would be allowed to apply for bail. Correct, yeah.
Madam Chair, I thank the Honourable Senator for raising the position. It's alerted me to the fact that we inadvertently have the word paragraphs 3A, B, and C, and it really should be subsection. So there's that to be observed, first of all. But secondly, the reason why we have included A, B, and AC, that is the new positions, along with 3A, is they're all of the subtype of firearms. So we had sought to treat possession of firearm, as we did in 3A, similar to possession of prohibited weapons and trafficking in weapons. And therefore, we applied, because we had done it that way for firearms, we had applied it that way.
The only thing is, Honourable Attorney General, through you, with respect to 3A, you would have persons who would fall under the charge or
Yes.
conviction charge. But now with 3AB and 3AC, you would have the persons who would have, there would be some persons who have no pending, no previous, who would now also be denied bail for as long as the trial takes place, which I thought to be, even if we are to consider accepting 3AB and 3AC as they are, to have that person now be denied bail until the matter is concluded, just by the very statistics that you would have read in your summation, it would be...
Forgive me for interrupting. It's a
Yes, of
very
course.
novel suggestion that you're putting forward. And the novelty is that you're introducing the fact that persons who have these types of offenses, they have a charge for this type, should not have the same treatment as people who lightning struck twice.
Correct.
And that they should have the ability to knock on the door of the court. Right? But you just said something that was extremely important, provided you're willing to accept the former, which is keeping 3A and 3B on a single strike. If you are prepared to do that, that might be something that is definitely worth the while talking about. Because what you're now proposing is you'll accept the fact that you must show exceptional circumstances for the 120 days, effectively. And you're saying, look, because these people only have one strike against them, one charge, give them the opportunity to approach the court after 120 days, whether their trial has started or not. If the opposition is prepared to accept that, right now I can say yes to that. I fear that you may have angered Senator Mark, because that is a very sensible submission. It might even persuade Senators Vera and Richards. So you're withdrawing that submission? Senator Sobers, again, I submit that you're on the wrong bench. And I mean that in the best way possible. That was a sensible submission, eminently sensible.
Senator Vera, Senator Richards, anything on the amendment proposed by Senator Mark to 3C? No? So it seems that I'm going to have to break up the amendment into, as proposed at 3A and then as proposed at 3C? Yeah? Yeah, okay, all right. So all right, members, at this stage, I'm going to put, it's one amendment to clause 3. It's, all right? So, honorable senators, the question is that clause 3 be amended as circulated by Senator Mark. Those in favor say aye. Aye. Those against say no.
No. Division. Mr. Khan?
No.
Mrs. Batiste Primus?
No.
Mr. Rambarat?
No.
Mr. Sinanan?
No.
Mr. Moses?
No.
Mr. Hussein? No. Ms. West? No. Mr. Lehant?
No.
Ms. Cox?
No.
Mr. Singh?
No.
Mr. De Freitas? No. Mr. Cummings?
No.
Mr. Dookie?
No.
Mr. Young?
No.
Mr. Boris?
No.
Mr. Mark?
Yes.
Mr. Hussein?
Yes.
Mr. Sobers?
Yes.
Ms. Haynes?
Yes.
Mr. Ubika?
Yes.
Mr. Zakur?
Yes.
Mr. Richards?
No.
Mr. Vera?
Yes.
Dr. Dial Singh?
Yes.
Dr. Dial Singh?
Yes.
Ms. Yunarang?
No.
Ms. Sipasad?
No.
Mr. Timal?
No.
Mrs. Thompson-Ai?
No.
Dr. Remy?
No.
Mr. Drayton?
No.
Honorable senators, the result of the division is as follows. 8 members voted for the amendment, 22 members voted against the amendment, and no one abstained. So the amendment was not accepted. Honorable senators, the question is that clause 3 now stand part of the bill. Those in favor say aye.
Madam President, Chair, sorry, you did note that I had observed, thanks to Senator Sobers, the need to just amend in subclause C paragraphs to the word subsection.
And Madam Chair, if I could, just,
So that the amendment as proposed by Senator Mark has not been accepted. Senator Richards?
just for clarity from the Attorney General, 3A, B, grenade, bomb, or other like missile, is that legal phrasing or is it an error?
It is taken exactly from the definition of prohibited weapons minus noxious substances. We didn't want to catch tear gas because we're about to introduce pepper spray, for instance, to assist women and men in the other way. So pepper spray we didn't want to include as a noxious substance. Yeah.
It just reads like if.
So a grenade can actually be launched by a rocket-propelled grenade. An RPG launches grenades. So they are technically a missile. The question is how you deliver it.
Honorable Senators, the question is that Clause 3 be amended as follows and as proposed by the Attorney General by deleting at 3 subsection C the word paragraphs and substituting the word subsections.
Yes, Madam Chair.
Yeah? Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. Honorable Senators, the question is that Clause 3, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. Clause 3, as amended, now stands part of the bill. Yeah, okay.
Propose new clause 4.
Honorable Senators, the question is that new Clause 4 be read a second time. Those in favor say aye. Aye. Those against say no. I think the ayes have it. New Clause 4 will now be read a second time.
New clause 4.
The question is that, oh, yes.
Senator Marcus.
Senator Mark, you have to give us some guidance on new Clause 4.
I would say out of an abundance of caution, I would have liked to have this provision, or this clause rather, inserted in the legislation. Now, I know the Attorney General indicated that it is part of the overall Bail Act, and therefore it automatically will fall by the wayside come the 5th of August 2022, given the 3-year sunset clause. But I see no harm in having it inserted in this amendment once the AG is willing to facilitate it.
Madam Chair, I understand the concern offered by my learned colleague. We have taken advice on the issue. A, in the St. Omer judgment, it's canvassed, and B, the CPC's department is insistent to me, and I agree with them that it is not required. But in any event, and I take Senator Mark's caution, out of an abundance of caution, I put it on the record expressly that the law will collapse, and the government's intention is, of course, that that happen when the sunset is considered with the ending of Act number 17 of 2019.
So, Honorable Senators, the question is that new Clause 4 be added to the bill. Those in favor say aye. Those against say no.
No.
I think the noes have it. New Clause 4 is therefore not added to the bill.
The preamble.
Honorable Senators, the question is that the preamble be approved. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. The preamble is therefore approved. Honorable Senators, the question is that the bill as amended be now reported to the Senate. Those in favor say aye.
Aye.
Those against say no. The bill as amended will now be reported to the Senate. Members, please, we are still having a sit-in, okay? Attorney General.
Madam President, I wish to report that a bill entitled An Act to Amend the Bail Act, Chapter 460, was considered in Committee of the Whole and approved with amendments. I now beg to move that the Senate agree with the committee's report.
Honorable Senators, the question is that this Senate agree with the committee's report on a bill entitled An Act to Amend the Bail Act, Chapter 460. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Attorney General.
Madam President, I beg to move, sincerely so, that a bill entitled An Act to Amend the Bail Act, Chapter 460, be read a third time and passed.
Honorable Senators, the question is that a bill entitled An Act to Amend the Bail Act, Chapter 460, be now read a third time and passed. Those in favor say aye. Aye. Those against say no. I think the ayes have it. This bill, Honorable Senators, as you know, requires a 3/5 majority, and therefore a division will be conducted by the clerk.
Mr. Khan,
Yes.
Mrs. Batiste Primus,
Definitely yes.
Mr. Rambarat,
Yes.
Mr. Sinana,
Yes.
Mr. Moses,
Yes.
Mr. Hussain, Ms. West,
Yes.
Mr. LaHunt,
Yes.
Ms. Cox,
Yes.
Mr. De Freitas, Mrs. Singh,
Yes.
Mr. Cumming,
Yes.
Mr. Dookie,
Yes.
Mr. Young,
Yes.
Mr. Boris,
Yes.
Mr. Ma,
Abstain.
Mr. Hussain,
Abstain.
Mr. Sobers,
Abstain.
Ms. Haynes,
Abstain.
Mr. Obika,
Abstain.
Mrs. Zakura,
Abstain.
Mr. Richards,
Abstain.
Mr. Vera,
Abstain.
Dr. Dial Singh,
Yes.
Ms. Deonarine,
Yes.
Ms. Sipasad,
Yes.
Mr. Timo,
Yes.
Mrs. Thompson-Ahi,
Aye.
Dr. Dylan Remy,
Yes.
Mr. Drayton,
Yes.
22. Madam President, the result of the division was as follows. 22 members voted for and 8 members abstained. There were no members voting against it.
Honorable Senators, the result of the division is as follows. 22 members voted for the bill, 8 members abstained, no one voted against the bill. The bill has therefore been passed.
A bill entitled An Act to Amend the Bail Act, Chapter 460.
Thank you very much, Madam President. Madam President, I beg to move that the Senate do now adjourn to Tuesday, the 26th November at 10 a.m. During that sitting, we'll be doing Bill number 4 on the order paper, a bill entitled An Act to Amend the Criminal Law Act, Chapter 1004, the Prisons Act, Chapter 1301, the Police Service Act, Chapter 1501, the Immigration Act, Chapter 1801, the Fire Service Act, Chapter 3550, and the Custom Act, Chapter 7801.
My colleague probably with the elections around the corner, a bit confused. He would know that under the standing orders, the fourth Tuesday is private members' day, and private members on the 26th. So I think he would want to deal with those matters after private members' day, which would be the following Tuesday.
And may I suggest that the members deal with that while I deal with what comes next? So, honorable senators, before I put the question on the adjournment, leave has been granted for two matters to be raised. Senator Dylan Remy.
Madam President, I wish to withdraw my matter.
Senator Mark.
Yes. Madam President, the matter that I'd like to address deals with the failure of the government to provide critical resources to MTS. Madam Chair, I do not know if my colleagues are aware that this very important institution known as the National Maintenance, Training and Security Company that does outstanding work for government ministries, government agencies, state enterprises, statutory authorities, among others, has been experiencing a crisis of cash. Recent reports when I filed this motion revealed that up to that time, which was a few months ago, the government had owed MTS close to $300 million and rising. Many of the ministries have not been paying MTS their bills on time. My information is that the recent budget that was passed resulted in some of the government ministries seeking to correct their deficits and the outstanding sums of monies owed to MTS. Madam President, whilst they were owing these hundreds of millions of dollars to MTS, hundreds of workers were unable to access funds that were deducted via credit union deductions based on loans that they had with their respective credit unions. Those loans were not being serviced. Some of them had medical plans, medical insurance plans. Monies were being deducted, but the monies was not being directed to the particular insurance company. So a lot of the workers suffered enormously during that period. I think it's incumbent upon government agencies to meet their obligations to MTS on a more timely and reasonable basis. So I have raised this matter this evening to get from the government a status report on monies that are outstanding to this very important state enterprise. I hope that the minister would be in a position to give us a detailed breakdown as to how much is outstanding as we speak, and when will the various bills that are outstanding be satisfied so that MTS can continue to perform the service that it does on behalf of the people of Trinidad and Tobago. So, Madam President, it is really an attempt on my part to get a status report on this matter so that Trinidad and Tobago and the people at MTS, that is the workers and the union, and of course the employees, management included, would have a better understanding of where MTS stands at this time from a financial perspective and point of view. So with these few words, Madam President, I look forward to the Honorable Minister of Public Utilities providing some clarification on a status report on MTS at this time. I wish to thank you, Madam President.
Minister of Public Utilities.
Madam President, for once another time, I am getting a question by Senator Mark, where he is asking for information, and if properly posed, I have no problem in giving a status report at MTS. However, the question that was posed to us in the Senate clearly didn't ask for that. The Senate question as posed, and I read, the failure of the government to honor outstanding payments of approximately $300 million to workers of the National Maintenance, Training and Security Company Limited. This talks about MTS, all right, owing workers of the National Maintenance Training Company Limited some $300 million. Madam President, there's a simple difference between accounts payable and accounts receivable, all right? If MTS owes their workers, that is an accounts payable. Money owed to MTS is an accounts receivable. This question that was put to me talks about accounts payables, money that MTS owes to their workers. And I am clear to say here emphatically in answering the question that was put to me that MTS never at any point in time owed any workers any amount of $300 million. From an accounts payable perspective, that is erroneous, that is not so, and they do not owe any workers $300 million, as posed in this question. As for the other side, as I heard now coming out, what Mr. Mark would really like to find out about money owed to MTS, all right, what I could say at this point in time, that MTS has all their bills that they have collected, they have made all their payments with regard to, there's still some funds that are from some of the government ministries that are owed to MTS. I didn't walk with that information because it was not the question that was being asked. But in any course of business, you will have an accounts receivable situation. It is in the normal course of business. MTS continues to be a very profitable entity. As of their last financial statements, they made, as of the financial year ending 2018, they had a profitability of $1.7 million, and the company continues to be profitable. All deductions that were taken out of the employees' accounts have all been settled and paid to their respective places that they are owed. So again, in answering the question that was posed, which is talking about $300 million, approximately $300 million, owed to workers of the National Maintenance, Training and Security Company Limited, There has never been that amount of money owed to workers by MTS. Never been. So with that, I am simply, that is the clear position, and MTS continues to be a profitable entity. Thank you very much.
Leader of Government.
Thank you very much, Madam President. Madam President, I crave your indulgence to remove again the adjournment. Not very often in the Senate does Senator Mark get a chance to correct me, but I humbly genuflect towards him in this regard. Madam President, I beg to move that the Senate do now adjourn to Tuesday, the 26th November at 1:30 p.m. Private Members' Day. And once Senator Mark indicates to me what motion, there are 10 motions here, I will inform this Honorable Senate as to what motion we'll be doing next week, Tuesday. I thank you.
I shall communicate with my friend.
Senators, the question is that this Senate do now adjourn to Tuesday, the 26th of November, 2019 at 1:30 p.m. Those in favor say aye. Aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to Tuesday, the 26th of November, 2019 at 1:30 p.m.